Are you tired of the time, cost, and emotional strain of traditional litigation? ADR offers a smarter, faster, and more collaborative way to resolve conflicts. We'll explore the key methods: adjudication, mediation, conciliation, and the role of ombuds, detailing their advantages, limitations, and practical applications. This presentation is part of the Whole Law series, where Dr. ioannis.glinavos breaks down complex legal concepts in comprehensive, hour-long podcasts. In this episode, we're diving into the world of alternative dispute resolution, ADR, your gateway to settling disputes without the courtroom drama. While the presentation is narrated by an AI voice, rest assured that the material behind it are very much put together by an expert. Together, we will discover how these methods can provide a cost-effective, timely, and satisfactory alternative to court proceedings, and learn about the UK legal framework that supports ADR. Plus, we'll discuss real-world examples, including government endorsements and pivotal case laws that highlight the impact and efficiency of ADR. Join us to understand how ADR can transform the way you approach legal disputes, ensuring you stay informed, empowered, and ready to choose the best path to resolution. Let's get started. While traditionally, resolving disputes has been associated with court proceedings, civil litigation processes can be time-consuming, expensive, and emotionally draining. Increasingly, alternative dispute resolution, ADR, mechanisms provide efficient and effective ways to resolve disputes outside of courtrooms. ADR includes various methods such as negotiation, mediation, and arbitration, and is gaining popularity due to its ability to offer a less formal, less adversarial, and more collaborative approach to dispute resolution. This podcast will focus on ADR mechanisms as means of resolving disputes, exploring their advantages, limitations, and practical applications. It will provide an overview of adjudication, mediation, conciliation, and the operation on ombuds, examining the theoretical foundations of each, their procedural aspects, and the context in which they are most effective. The podcast will also consider the role of legal practitioners, judges, and other professionals in facilitating the use of ADR, as well as the ethical and regulatory frameworks that govern these mechanisms. Ultimately, this podcast allows the reader to evaluate the hypothesis that ADR offers a viable alternative to traditional court proceedings, providing parties with a range of options to resolve disputes in a cost-effective, timely, and satisfactory manner. The UK government advocates the use of ADR, as illustrated by the inclusion in the Civil Procedure Rules 1998, the CPR, of several measures designed to encourage such processes. The CPR require parties at various stages before and during litigation to consider whether ADR might be appropriate as a means of settling their dispute. If they decide it would be beneficial to try ADR, the court will usually stay the proceedings while they do so. Lord Justice Jackson's 2010 final report on civil litigation costs dedicated an entire chapter to the benefits of ADR. The use of ADR, and in particular mediation, has been sanctioned by courts, with the consequence that parties who have unreasonably refused to mediate have been penalized in costs after trial, regardless of whether they have been successful or unsuccessful overall. Case law has established that a party who has unreasonably refused to attempt ADR may face costs sanctions at the end of litigation, and this is now reflected in the CPR, practice direction, pre-action conduct, and protocols. We start our exploration of the ADR landscape by looking at adjudication. Adjudication is an alternative dispute resolution, ADR mechanism, that is typically less formal than final resolution processes like litigation or arbitration. In this process, the decision made by the adjudicator is not binding on the parties in the same way that final resolution processes are. Adjudication is commonly used in consumer cases where the outcome may be binding on the company, but not on the consumer. This type of ADR involves an independent third party, known as an adjudicator, who is responsible for reviewing the claims of both sides and deciding based on best practice standards in the relevant industry. Adjudication is usually carried out through written documentation provided by both parties, along with any relevant evidence. Although the adjudicator is not necessarily legally qualified, they are typically knowledgeable about the industry and subject matter of the dispute. Adjudication is most used in dispute resolution schemes run by trade associations that aim to handle consumer complaints, or in schemes designed to resolve low-value and low-complexity disputes involving service providers. Additionally, most adjudication schemes are free of cost to the consumer. We now move on to mediation. Mediation is an alternative dispute resolution (ADR) process in which an independent third party, known as a mediator, assists parties involved in a dispute to reach a mutually agreed-upon resolution. Unlike final resolution processes such as litigation or arbitration, the mediator does not offer a decision or issue any orders. Instead, the parties themselves are responsible for determining if they can resolve their differences and what an acceptable outcome would be. The mediation is a structured process that involves several stages, with the mediator overseeing the process. It is voluntary, private, and confidential, and does not prejudice any trial process that may follow. The mediation is a widely used ADR process that is used in various areas, including business-to-business contracts, consumer contracts, divorce and separation cases, education, housing, and medical negligence disputes, including personal injury claims, depending on the jurisdiction. Workplace and employment disputes are also commonly resolved through mediation, and the process can involve two or multiple parties, including entire communities, depending on the situation. Mediation typically takes place in a neutral venue, and most mediation providers have their own offices where meetings and discussions can take place. It often occurs at a face-to-face or online synchronous meeting between the parties in dispute. In some cases, the parties may stay in separate rooms, with the mediator moving between locations with ideas and responses. This is known as shuttle mediation. The cost of mediation varies depending on the type and circumstances of the case. Family mediation is usually offered at an hourly rate, sometimes on a sliding scale based on the income of the participants. Civil and commercial mediation rates tend to be more expensive and are usually based on the value of the dispute or claim. Small claims mediation is provided by a court-based mediation officer and is free once the court application fee has been paid, as it is part of the staged process of dealing with claims through the court system. This type of mediation is offered if all parties involved agree to use the service. The claim is up to £10,000, and the parties have already made or received a claim. Cases that could typically benefit from this type of mediation include parking penalties, online shopping, building works, unpaid invoices, livestock, or pet expenses. In mediation, there are no predetermined outcomes, and the mediator does not offer judgment or a solution. The outcome of a mediation process is expressed in a contractual document to become enforceable. The parties can agree to include various terms in this contract, such as an apology, an explanation, a change in behavior, policy, or procedure, a promise to do or avoid doing something, an agreement about contact or residence arrangements for children, an agreement about property or financial arrangements after separation or divorce, compensation, refunds, or the replacement of goods. If both parties agree, they can ask the court to turn their mediation agreement into a court order, which can be enforced directly through the court. However, it is more common to seek enforcement of agreements by unwilling parties through a breach of contract action. We now move on to conciliation. Conciliation and mediation have similarities. In both, an impartial third party, such as a conciliator or mediator, helps individuals in conflict to reach an agreement. The conciliator remains impartial and does not take sides, and the disputing parties are responsible for deciding how to resolve the dispute. In some cases, conciliation is used as the main form of ADR for resolving disputes, even though it is essentially the same process as mediation. All conciliation processes share the characteristics of being voluntary, private, and confidential. Parties are free to agree or disagree with the resolution. In the UK, the most well-known conciliation service is ACAS, which is used to resolve employment disputes. Conciliation can seem like the negotiation phase of dispute resolution, but it differs in that the conciliator is impartial and independent. Conciliation is free for the complaining party, and depending on the scheme, the agreement reached may be binding. For example, a signed agreement reached through ACAS conciliation is binding on both the employee and the employer. Since conciliation is private, the settlement terms are not disclosed unless the parties agree. The outcomes of conciliation are likely to be like those of mediation. Ombuds, a gender-neutral term for ombudsman, perform a different function than adjudicators, mediators, and conciliators. They investigate and resolve complaints about organizations and government bodies and encourage good complaint handling practices. There are two main types of ombuds: public sector ombuds, who investigate complaints about local councils, government departments, and the NHS, and private sector ombuds, who investigate complaints about various businesses such as banks, insurers, telecommunication providers, and estate agents. Many private sector ombuds have a statutory basis and are approved by sector regulators or the relevant government department. Ombuds are independent of the bodies they investigate, and their services are free to complainants. Organizations that subscribe to ombuds schemes must follow their decisions, or at least have a reasonable expectation of doing so. However, ombuds do not provide legal advice, so it's wise to seek independent advice before making a complaint to an ombuds and consider whether it's the best way to resolve the dispute. Ombuds use an inquisitorial method of dispute resolution, meaning they ask questions to both sides to establish the facts. They typically attempt to resolve complaints informally first, by helping both sides reach an agreement. In some ombudsman services, the complainant decides whether to accept the proposed agreement. If they are not satisfied with the proposed solution, they can ask the ombuds to continue the investigation and make a recommendation. In other services, it is up to the ombuds to decide whether a proposed solution is appropriate. If the complainant is not happy with the ombuds' decision, they can still take the original complaint to court or arbitration. Ombuds can recommend or order various remedies, including an explanation, an apology, a change in practice, payment of out-of-pocket expenses, or compensation. All ombuds can award or recommend financial compensation within limits. However, the compensation may be lower than what a court would order, so it's essential to consider this when deciding how to resolve a dispute. One of the key advantages of public sector ombuds is that they can ask an organization or government department to review complaints involving similar issues. For example, a sample complaint about a public function could lead to a review of the entire system, improving it for many people who haven't approached the ombuds yet. There is no appeal against an ombuds decision, but all ombuds schemes have their own complaints process if the complainant is not happy with how their case was handled. This podcast introduced you, so far, to the key ADR mechanisms prevalent in the UK. Alternative dispute resolution, ADR, is gaining popularity as a cost-effective, timely, and satisfactory means of resolving disputes outside of courtrooms. ADR includes various methods such as negotiation, mediation, and arbitration. This podcast has explored the advantages, limitations, and practical applications of ADR mechanisms, examining their legal foundations, procedural aspects, and the contexts in which they are most effective. The podcast has also considered the role of legal practitioners, courts, and other professionals in facilitating the use of ADR, as well as the ethical and regulatory frameworks that govern these mechanisms. The UK government encourages the use of ADR, and the Civil Procedure Rules 1998 include measures to encourage such processes. Unreasonable refusal to attempt ADR may result in cost sanctions at the end of litigation, as established by case law and reflected in the CPR. Overall, ADR offers a viable alternative to traditional court proceedings, providing parties with a range of options to resolve disputes in a less formal, less adversarial, and more collaborative manner. We now move on to arbitration. Arbitration has become an increasingly popular method for resolving disputes in many areas of the law, in a domestic and international context. It offers a flexible and efficient alternative to traditional litigation, which can be time-consuming, costly, and unpredictable depending on jurisdiction. Arbitration allows parties to select an impartial arbitrator, or a panel, who will hear their dispute and render a final and binding decision. This process allows for a more streamlined and tailored approach to dispute resolution, with parties able to choose the rules and procedures that will govern their arbitration. Moreover, the confidentiality of the arbitration process means that sensitive or private matters can be resolved without the risk of public exposure. In this podcast, we will explore the benefits of arbitration, as well as the key considerations that parties should keep in mind when deciding whether to pursue this method of dispute resolution. Note that while there is no one accepted definition of ADR, there is some controversy over whether arbitration should be perceived as part of ADR or be held separate. The U.S. tradition includes in the definition of ADR all dispute resolution methods, and therefore arbitration, other than court proceedings. In the UK, on the other hand, ADR is generally understood to describe all non-adjudicative dispute resolution methods other than court proceedings and arbitration. The reason for this is that court litigation and arbitration are both final resolution systems, while ADR does not lead to mandatory outcomes for the participants. In this module, we discuss arbitration as part of the wider ADR ecosystem. Arbitration is the procedure via which a dispute is submitted, by agreement of the parties, to one or more arbitrators who make a binding decision on the dispute. The key distinguishing point between arbitration and other methods of ADR we encountered already in the guide is the fact that arbitration is a final determination process. The parties cannot disagree and ignore the outcome of an arbitration. In choosing arbitration, the parties opt for a private dispute resolution procedure instead of going to court. The principal characteristics of arbitration are that it is consensual, that the parties choose the arbitrators, that it is neutral, confidential, and has an established pathway to enforcement both domestically and internationally. We will now examine these key characteristics in some more detail. Arbitration can only take place if both parties have agreed to it. A common way in which an arbitral tribunal attains jurisdiction to hear a future dispute arising under a contract is through the insertion of an arbitration clause in the relevant contract. Alternatively, an existing dispute can be referred to arbitration by means of a submission agreement between the parties. As arbitration is a binding and final determination process, as opposed to other types of ADR, a party cannot unilaterally withdraw from the process and return jurisdiction to a national court. Arbitral tribunals consist of a single or more arbitrators selected by the parties. If they choose to have a 3-member arbitral tribunal, each party appoints one of the arbitrators. Those 2 persons then agree on the presiding arbitrator. Alternatively, in institutional arbitrations, the relevant institution can suggest potential arbitrators with relevant expertise or directly appoint members of the arbitral tribunal. In addition to their selection of neutral third parties of appropriate nationality as arbitrators, parties can choose a great deal of the procedural aspects of the process, as the applicable law, language, and venue of the arbitration. This allows them to ensure that no party enjoys an advantage and can help tailor the process to the needs and abilities of the parties. Depending on the type of proceedings, most arbitral rules applied by nation-states to facilitate the process specifically protect the confidentiality of the existence of the arbitration, any disclosures made during that procedure, and the resulting award. In certain circumstances, national law allows a party to restrict access to trade secrets or other confidential information that is submitted to the arbitral tribunal or to a confidential advisor to the tribunal. In England, arbitration is operationalized through the Arbitration Act of 1996 and the Alternative Dispute Resolution for Consumer Disputes, Competent Authorities and Information, Regulations 2015. Usually, the parties agree to carry out the decision of the arbitral tribunal without delay. If this does not take place, domestic legislation lends the tribunal the powers of the court to aid in enforcement. Remember that it is not possible to ignore an arbitral award, return the matter to consideration in the courts, or try another ADR method. The decision of the tribunal will be final, barring some limited opportunities for appeal. At the international level, specifically for commercial disputes, awards are enforced by national courts under the New York Convention, which permits them to be set aside only in very limited circumstances. Most commercially significant states are party to this convention on the recognition and enforcement of foreign arbitral awards, commonly known as the New York Convention, which was adopted by a United Nations Diplomatic Conference on the 10th of June, 1958. The finality of arbitration is respected at the international level as well. There are limited opportunities to appeal in most jurisdictions, and even where appeals are possible, they are usually about defects with process, not substance of the decisions. The New York Convention is the cornerstone of the modern law of international commercial arbitration. The origins of modern arbitration date from the 1920s. In 1923, the Protocol on Arbitration Clauses was signed by the League of Nations and occasioned the first multilateral text recognizing international arbitration by the global trade and commerce community. The New York Convention and its European equivalent, the European Convention on International Commercial Arbitration in 1961, established the international acceptance of extrajudicial dispute resolution in transnational commercial matters. A breakthrough came with the UN Commission on International Trade Law, UNCITRAL, arbitration rules of 1976, and the Model Law in 1985. The UNCITRAL rules were the first to reconcile some of the procedural differences between the common and the civil law, and the Model Law introduced the idea that it would be appropriate to have separate rules for domestic as opposed to international arbitrations. This allowed international commercial arbitration to become detached from the public policy restrictions of national courts. These two documents have been hugely influential in the development of national laws, recognizing and promoting as a cornerstone for the efficient resolution of disputes across borders. UNCITRAL itself does not participate in either public or private disputes, nor does it offer legal advice in specific disputes, and does not nominate arbitrators, administer arbitrations, certify arbitral authorities, or recommend any legal practitioner for legal assistance. A reference in an arbitration clause to the UNCITRAL arbitration rules, or to UNCITRAL arbitration, or any other provision to the same effect, means that the parties agree that an existing or a future dispute should be settled in arbitral proceedings conducted in accordance with the UNCITRAL arbitration rules. Remember, therefore, that although UNCITRAL and its Secretariat have prepared legislative and contractual provisions and rules relating to international commercial arbitration and conciliation, it is not within UNCITRAL's mandate, as set out by the UN General Assembly, to become involved in individual cases. The UNCITRAL Model Law provides a pattern that lawmakers in national governments can adopt as part of their domestic legislation on arbitration. The UNCITRAL arbitration rules, on the other hand, are selected by parties either as part of their contract or after a dispute arises to govern the conduct of an arbitration intended to resolve a dispute or disputes between themselves. Put simply, the model law is directed at states, while the arbitration rules are directed at potential or actual parties to a dispute. The latest version of the model law is from 2006, the original dating from 1985. The rules, from 1976, are a comprehensive set of procedural rules to be followed in arbitration which the parties can agree to adopt. They are widely used in ad hoc and institutional arbitrations alike. Arbitration is presented as the key alternative to litigation. This is because, from the array of options for alternative dispute resolution, only arbitration offers a binding outcome akin to litigation. The main advantages to arbitration are normally presented to be availability of and choice over qualified adjudicators, speed, lower costs, confidentiality, privacy of proceedings, flexibility of process, and ease of enforcement abroad. The NOIC makes the enforcement of arbitral awards easier than foreign court judgments. Additional benefits to arbitration, especially of the international type, are the neutrality of the forum and the finality of the process expressed through the very limited options for appeal and the lack of opportunity for appeal on substance. One should note that the lack of an opportunity of appeal can also be a disadvantage. Also, lacking coercive powers, a tribunal can have difficulty mandating evidence production or forcing parties to comply with orders and directions. To make matters worse, a tribunal has no power over third parties. As to choice over process and arbitrators, this is celebrated in theory, but can be complicated in practice, as imperfect information can undermine choices. This is precisely the reason for the popularity of arbitral institutions that offer a contained menu of choices to parties less familiar with the arbitral process. Also, having the choice in theory does not mean you have it in practice, as there is still a limited pool, in terms of gender, ethnicity, and background, of international arbitrators. A common concern about litigation is the lasting damage it does to continuing business relationships. Uncertainty about contract performance is normally reduced by adopting widely accepted local norms and through close personal relationships. If the same individuals occupying roles in contracting businesses have dealt with each other for years, informal avenues of communication can help avoid disputes and increase successful contractual performance. The same goes for executives who may also know each other. This allows disputes in the business community to be settled without reference to the contract or potential or actual legal sanctions. Parties involved in an ongoing mutually beneficial relationship, possibly with dealings along many different fronts, are less likely to rely on highly institutionalized forms of dispute resolution than parties with no anticipated future relationship. There are two main reasons for this. First, parties in a continuing relationship can more easily control each other because the expected future gains lock them in a win-win situation. Thus, each other's behavior is quite predictable, as parties have little to gain, but potentially much to lose, from being uncompromising and confrontational. Second, parties in a continuing relationship typically have good information about each other's past behavior, past problems, and past solutions. This knowledge may be usefully brought to bear in a new instance of conflict. Such mutually productive relationships risk breakdown if the parties resort to litigation after failing to informally resolve a dispute. ADR in general, and arbitration in particular, is seen as a formalized way to resolve a dispute that requires the intervention of an external decision-maker without impacting the reputational damage and complete break in relations than a public dispute in a civil court can inflict. ADR can provide, therefore, effective means of resolving disputes between parties who have an interest in maintaining an ongoing business relationship. The parties are likely to approach the process in a spirit of negotiation and compromise, instead of adopting the adversarial positions associated with litigation. In the area of costs, however, the assumption that arbitration is less costly than litigation is often wrong. Of course, the decision to adopt arbitration as opposed to litigation as the mode of dispute resolution in a particular contract is not solely made based on costs. There can be cost incentives for the parties to commit their disputes to an arbitration rather than remain in litigation. For further information on costs in arbitration, you are invited to read the ICC Arbitration and ADR Commission Report on Decisions on Costs in International Arbitration. This podcast introduced you to arbitration, a method of ADR that is becoming increasingly popular for the settlement of civil disputes both at the national and international level. Its numerous benefits, including flexibility, efficiency, and confidentiality, make it an attractive alternative to traditional court litigation. Arbitration offers parties the opportunity to select an arbitrator who has specific expertise in the subject matter of the dispute, ensuring a fair and knowledgeable decision-making. Additionally, arbitration awards are generally binding and enforceable, providing parties with a final resolution to their dispute. At the international level, arbitration is particularly useful for resolving cross-border disputes where parties may face difficulties navigating the different legal systems and procedures of various countries. International arbitration provides a neutral forum for resolving disputes that avoids the potential biases of domestic courts and ensures consistent and uniform outcomes. Despite its many advantages, arbitration is not without its challenges. The cost of arbitration can be significant, and parties must carefully consider the potential benefits against the potential costs before agreeing to arbitration. Moreover, arbitration agreements must be carefully drafted to ensure that all parties understand the scope of the agreement and the potential consequences of agreeing to arbitrate. Alternative dispute resolution, ADR. Methods such as mediation and arbitration have gained popularity in recent years as means of resolving disputes outside of the traditional court system. This podcast further examines the degree to which ADR could be fully integrated into the civil litigation process. The integration of ADR into the civil litigation environment, usually as a precursor to litigation, is aimed at making dispute resolution quicker and more cost-effective compared to the traditional litigation process. ADR can also be more flexible and allow parties to come up with solutions that better meet their unique needs, whereas court-imposed remedies may not be as tailored. Crucially, ADR can help preserve relationships between parties, which can be particularly important in business or personal relationships. By integrating ADR into the civil litigation process, parties can be encouraged to explore alternative options before incurring the cost and inconvenience of resorting to court action. Finally, in systems experiencing workload pressures, diverting dispute resolution to ADR can free up valuable court time. However, ADR is not always suitable and not appropriate for every case. Some disputes may require the formality and structure of the court system to reach a fair resolution. Additionally, while ADR may be more cost-effective in some cases, it may not always be cheaper than litigation. For example, if parties cannot come to an agreement in mediation, they may need to resort to litigation anyway, resulting in increased costs. Furthermore, the lack of formal precedent in ADR decisions may create uncertainty in the law and potentially lead to inconsistent outcomes. There is also the very important issue of access to justice being a human right, fundamental to the constitutional provisions of most nations. Making access to the courts dependent on ADR processes has the potential to violate a right to a hearing before a court of law. The podcast begins with this crucial consideration of ADR and human rights. There is a long debate in the literature on the extent to which civil litigation processes should incorporate ADR, and the extent to which this should be obligatory for the users of the justice system. Whether and how the use of ADR can be encouraged or required will vary widely depending on the context, the value of the claim, the different subject matters in dispute, and to some extent, upon whether the parties are likely to be advised or represented by solicitors. Compulsion need not simply involve the exercise of a case management power by a judge in each case. It can also be achieved by mandating participation in ADR as an automatic requirement for commencing or proceeding with litigation. The problem comes from Article 6 of the European Convention of Human Rights, incorporated in English law through the Human Rights Act 1998, on a right to a fair trial. The article prescribes that in the determination of his civil rights and obligations, or of any criminal charge against them, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. Judgment shall be pronounced publicly, but the press and public may be excluded from all or part of the trial in the interests of morals, public order, or national security in a democratic society, where the interests of juveniles or the protection of the private life of the parties so require, or to the extent strictly necessary in the opinion of the court in special circumstances where publicity would prejudice the interests of justice. Offloading civil disputes to ADR, or making ADR a precondition to accessing the courts, could violate this obligation. But to what extent is ADR part of the civil litigation landscape in England and Wales? The following areas represent examples where ADR mechanisms have been integrated into the civil justice landscape in this jurisdiction. First, there are early neutral evaluation (ENE) hearings, which involve a neutral party with relevant legal expertise convening a hearing in which they express an opinion about a dispute or one element of it. Under CPR 3.12 M, the court has the power to order the parties to attend an ENE without their consent, if appropriate, usually in financial remedy cases. The second example involves financial dispute resolution, FDR appointments in family cases. FDR is a court-assisted negotiation process where the parties appear before a district judge in a without prejudice hearing, intended to facilitate settlement. This is a standard compulsory part of the procedure to be followed when a party makes an application for a financial remedy under Part 9 FPR, and usually takes place following the first directions hearing. Both parties must attend the FDR, unless the court orders otherwise. The third example can be found in the Small Claims Protocol for personal injury claims arising from road traffic accidents. Since May 2021, claimants in low value, less than £5,000, cases must follow a new pre-action protocol whereby the claimant must provide certain information via an online portal, and where liability is admitted, the defendant's insurer must make a settlement offer within a set time frame. The protocol makes clear that parties are expected to attempt to settle the claim, and failure to follow the protocol by either party will result in consequences in any related litigation. A fourth example can be found in ACAS early conciliation, where a person may not present an application to institute employment tribunal proceedings without first obtaining an early conciliation certificate from ACAS. This amounts at least to compulsory initial contact with an ADR provider, even if the process is not actually utilized. A fifth example is Mediation Information and Assessment Meetings, MIM. A MIM is required before making certain applications in family proceedings, including private law applications relating to children and proceedings for a family law-related remedy. Regarding compulsion to use ADR, case law seem to authorize courts to compel a party to mediate, even when they are unwilling to do so. In Shirayama Shokusan Company Limited and Others versus Danovo Limited in 2003, The court ordered mediation to take place, despite the unwillingness of the claimant. However, the court did decide that continuing to delay a hearing to require the attendance at mediation of a person who is not a named party to the proceedings would infringe Article 6 of the European Convention on Human Rights and have the effect of denying the parties the right to a fair trial. The Halsey judgment, see below, reversed the trend towards compulsion and makes it clear that courts cannot force unwilling parties to mediate. In terms of costs, in the case of Dunnett v. Railtrack, the winning party, Railtrack, was required to pay the costs of the case, despite being successful at appeal, because of refusing an offer to mediate from Ms. Dunnett. Following this decision, an offer to mediate has subsequently been used by potentially weaker parties as a tactic to try to persuade the stronger party to settle on the grounds that they risked an adverse costs penalty for refusing ADR. In the case of Halsey versus Milton Keynes in 2004, the judges commented that the mediation offers from the claimant's solicitor were somewhat tactical. This judgment puts the burden on the unsuccessful party to demonstrate that the successful party's refusal to mediate was unreasonable. In terms of government policy, the Lord Chancellor had pledged in March 2001 that government departments would use ADR to resolve disputes wherever appropriate. In the case of Royal Bank of Canada versus Secretary of State for Defence in 2003, the Ministry of Defence was penalized for refusing mediation in a dispute about a lease, which they believed needed judicial resolution because it involved clarifying a point of law. The court stated at the time that that was not a justifiable reason for refusing to mediate. However, the judges in this case have made it clear that the need to resolve a point of law is one of the factors to consider when deciding whether or not a party is reasonable in refusing mediation. They also decided that the pledge is just one more factor to consider when deciding whether a refusal to mediate is reasonable, and that it should not place any greater burden on public bodies than on individuals. While business parties may wish to subject their disputes to arbitration, there is concern about arbitration clause included in consumer contracts, when the consumer has no influence over the terms. Mandatory arbitration in consumer cases is treated differently depending on jurisdiction. In the USA, the Federal Arbitration Act makes agreements to arbitrate valid, irrevocable, and enforceable. See, for example, AT&T Mobility LLC versus Concepcion in 2011. In the EU, the position is different. Directive 2013/11, see Articles 10 and 11, provides that mandatory arbitration provisions will only apply in cases where the consumer as plaintiff is bound by an arbitration agreement, not if the trader himself initiates a claim in arbitration. Also, consumer arbitration is limited to actions in contract, except for non-economic services of general interest, excluding actions in tort and restitution. Injunctions against illegal behavior of traders sought by consumer associations are also excluded. Directive 2009/22 EU. In the case of Claro versus Centro Movo Millennium in 2006, the CJEU discusses the degree to which the national court must engage into investigations on its own motion regarding the legality of arbitration proceedings, as the potential unfairness of proceedings have to be determined by national law. It seems to be the intention of the EU to exclude pre-dispute arbitration clauses which are common in the US. In England, the Arbitration Act of 1996 already recognizes and incorporates the provisions on unfair terms in consumer contracts in the Consumer Rights Act 2015 in relation to a term which constitutes an arbitration agreement. Compulsory arbitration clauses relating to claims of £5,000 or less are automatically regarded as unfair. For claims over £5,000, such clauses are subject to the fairness test under the CRA 2015. The conclusion is that England is aligned with the EU position. Even though it is possible that corporations include an arbitration agreement in their standard consumer contract terms, they may not be able to enforce it in the English courts in disputes with UK-domiciled consumers. See Soleimani v. Nifty Gateway LLC in 2022. In Halsey v. Milton Keynes General NHS Trust in 2004, the court has made a distinction between the duty of the court to encourage parties to use mediation and the power to force parties to use mediation against their will. Lord Justice Dyson said, "It seems to us that to oblige truly unwilling parties to refer their disputes to mediation would be to impose an unacceptable obstruction on their right of access to the court." He quoted Article 6 of the European Convention on Human Rights in support of this, and distinguished between a voluntary agreement to waive access to a court, such as an arbitration clause, and compulsion by the court itself. Judges may well wish to explore with the parties the reason for an initial refusal to mediate, but it would be wrong for the court to compel them to embrace it. In terms of costs, the Civil Procedure Rules, CPR 44.3 paragraph 2, set out the general rule that the unsuccessful party should pay the costs of the successful party. Rule 44.3 paragraph 5 allows costs to be varied by the court, considering the behavior of the parties both before and during the proceedings, including their attempts to resolve the dispute, and whether or not they have followed any pre-action protocol. However, the court in Halsey made it clear that deciding to deprive a successful party of costs on the grounds that they have refused ADR should be an exception to the general rule that costs follow the event, and the burden should be on the unsuccessful party to show that the successful party acted unreasonably in refusing to agree to ADR. The factors considered when deciding whether a refusal to mediate is unreasonable should include the nature of the dispute, the merits of the case, the extent to which other settlement methods have been attempted, whether the costs of the ADR would be disproportionately high, whether any delay in setting up and attending the ADR would have been prejudicial, and whether the ADR had a reasonable prospect of success. This podcast introduced you to the concept of integration of alternative dispute resolution, ADR, processes in the civil litigation environment. Specifically, introduction of ADR as a prerequisite to litigation does not necessarily violate human rights with regards to access to a fair trial. In fact, ADR can be an effective and efficient means of resolving disputes without the need for costly and time-consuming litigation. However, the requirement to engage in ADR before accessing the court system can potentially be problematic if it is imposed as an absolute requirement without regard for the specific circumstances of the case. For example, if ADR is mandated in situations where it is not appropriate or feasible, this could result in a violation of the right to a fair trial. Furthermore, it is important to ensure that ADR processes are fair, impartial, and accessible to all parties, including those who may have limited resources or who may be marginalized in some way. If ADR processes are not transparent, or if there is unequal access to ADR services, this could also result in a violation of the right to a fair trial. We should also not overlook the fact that cases are important in allowing the law to evolve and for the courts to interpret legislative initiatives. Without an adequate flow of cases through the courts, the normal process of evolution of legal norms can be disrupted. In summary, while the use of ADR as a prerequisite to litigation can be beneficial, and English courts take the same view, penalizing parties in terms of costs, but not denying them access to trial if they fail to engage with ADR. As we conclude this episode on alternative dispute resolution, ADR, we hope you've gained valuable insights into how ADR can serve as a smarter, faster, and more collaborative alternative to traditional litigation. We've explored key methods like adjudication, mediation, conciliation, and the role of ombuds, highlighting their practical applications and benefits. Remember, ADR offers a cost-effective, timely, and satisfactory way to resolve disputes, backed by a robust UK legal framework and real-world examples. By understanding these mechanisms, you're better equipped to handle legal conflicts with confidence and efficiency. Thank you for joining us on The Whole Law. Stay informed, stay empowered, and see you in the next episode.